Okay, I wish to advise members that the committee meeting is now in public session and will be recorded and broadcast throughout Parliament buildings and online. Apologies received from Jonathan Buckley and Emma Sheeran, Padraig Delargy and Kate Nicholl will be joining us slightly late. Item 2, declarations of interest, members, any?
Just the student one for my daughter, yeah.
Any others? None. Okay. Item 3, then, members, is chairperson's business. At item 3.1, in a response to AQW 32606, the Minister advised of a report on the need for a net zero acceleration fund. Members content to seek sight of that report?
Yep.
Thank you. Item 3.2, in a response to written questions, the Minister referred to 2 consultations on grid connection and low carbon heat were launched in January 2025, but yet the committee has received no update on those. Is the committee content to write to seek an update on those? Thank you. Item 4, then, members, at page 7 is the minutes from our deliberations on the 8th of October. Members content that I sign those as a true and accurate reflection? Yep. Great. Yep. If there's no matters arising, then members will move straight to our first evidence session with the Law Society for Northern Ireland. The committee will receive evidence from the Law Society of Northern Ireland in respect of the Insolvency Amendment Bill. This session will be recorded by Hansard. I'm delighted to welcome Claire McNamee, who is a conveyancing and non-contentious business lead at the Law Society, Richard Craig, partner at Mills, and we have Maria Glover as well. So colleagues, you're very welcome, and I'm happy to hand over to you at this stage to give the committee the overview of the bill as it currently stands.
Perfect, thank you. Thank you for the invitation for the Law Society of Northern Ireland to appear before this committee today. We do welcome the objective to update the legislation, especially with administrative matters such as removing requirements for physical meetings, for example. Only one point, which was not an objection, we raised was in relation to the statement of affairs being changed from only when on request by the official receiver. As noted in our submission, the Society remarked on the criminal offence arising from not providing a statement of affairs within the allotted 21 days. The Insolvency Service proactively contacted the Society following the consultation response and noted that in practice they utilise a non-statutory preliminary inquiries questionnaire, and they use that in all cases in 2023 and 2024. There have been no issues reported by the Insolvency Committee or the Insolvency Service in relation to this. The Society is of the view that if the Insolvency Service are satisfied with the arrangements, then ours is not an objection. That being said, it is noted that there is a change from this document being a statutory document to be replaced with a non-statutory document. There may be potential legal challenges if a bankrupt were, for example, to say they had not received a request to complete the questionnaire. The offence in a preliminary inquiries questionnaire is in providing false information, not in not returning it in the first place. We are keen that any changes are supported by appropriate guidance and training where possible to bed in the changes both for the profession and also for the public on the relevant websites. We would also just note in closing that the Insolvency Service have been very proactive in engaging with us when we raised our response to the insolvency consultation. Thank you.
Thank you. Anyone else from colleagues, or that's it? Yeah.
Yeah,
no problem at all.
So it wasn't a formal objection that we really had to the changes. It was just to note that one discrete point.
Okay. And in relation to that, then, so that the wording of it is when requested. Do you think then that the when requested should just be removed and it should be an automatic entitlement, or do you think that can be dealt with just in guidance then following the bill's passage?
I think there's a couple of queries there, because if the preliminary inquiries document, for example, was to become a statutory document that was to be furnished, then that might be, if the Insolvency Service think that that's an easier document to use and it's easier for members or a bankrupt to fill in, to then replace that. And then if a statement of affairs was then requested, if, for example, someone who was maybe reluctant to provide information, but it's the offence. So it's whenever you remove the stick as such to have to furnish something, then potentially that's where we identify a risk. But as I say, if the Insolvency Service are satisfied.
You're satisfied?
Mm-hmm.
Yeah. Okay. Diana, online.
Yes, good morning, and good morning to Claire and your colleagues. Thank you for coming in this morning. I just had one question. I can understand the move to the from statutory to to a provision or statement of affairs. So just wondering, should the bill include a clearer enforcement pathway for cases where the bankrupts fail to respond or or provide incomplete information?
Diane, it would be my view that that is already provided for within the general jurisdiction of the High Court.
Okay.
So if a bankrupt fails to comply, then the official receiver or the trustee in bankruptcy has the ability to revert to court to seek directions or to apply to extend the period of their bankruptcy by suspending their discharge from bankruptcy.
And that'll be made clear. Thank you, yes. And the other item or topic I was looking at is the digitally excluded creditors. What safeguards would you recommend to ensure that they're not disadvantaged by the move to virtual meetings?
I'm happy for you to take that one.
Well, I think in the first instance, the role of the insolvency practitioner and the official receiver will be to identify any potential creditors or to identify debtors or bankrupts who may have an issue in relation to access to digital services.
Yeah.
Because a lot of these cases you will have institutional creditors, and so you will see that these will run out as very standard in a lot of the vast majority of cases. But it will be quite clear if there are individuals who are personal creditors. It'll be obvious that that might be an issue. So one of the safeguards would certainly be always retaining an option. People can receive and can effectively decide how they receive communication from the insolvency service or from the trustee in bankruptcy directly. And there are a number of agencies which assist as well in the voluntary sector. And I think signposting and any opportunity to signpost to the voluntary sector, as well as obviously to the legal profession, I think would be an important safeguard.
Okay, lovely. Thanks for your answers. Thanks, Chair.
Thank you. And then just David.
Just you said about the kind of stick, and if you remove that, it's just do you think there's enough power there to make sure that everything's completed and done, and just checking that you're...
Well, it's a difficult one because if the insolvency service said, oh well, we did over 130 last year and we didn't have any issues, you know, in theory potentially there is, because the engagement there, and as Maria says, the inherent jurisdiction of the court. But it's just, you might have a particular bankrupt who maybe is more wily in certain things, and then it's like, is it an option to consider whether the preliminary inquiries document becomes a statutory document, because it's a contempt of court if you do then not complete it within those 21 days. So it's just whether or not had that option been considered to replace the statement of affairs with the preliminary inquiries questionnaire, and then if insufficient information was revealed in that, to then demand a statement of affairs that is more comprehensive.
So would you prefer it to be made?
I think it wasn't clear to us in the first instance on what basis the statement of affairs was being effectively removed as a compulsory requirement. We look back at the Deregulation Act upon which this bill is based, and it wasn't clear from that. It was I think the wording was that there wasn't enough awareness from bankrupts that they needed to address it. When we had engagement with the Insolvency Service made clear that effectively what has happened is that they ask every bankrupt to complete a preliminary examination questionnaire which runs to over 32 pages. It is extremely comprehensive. It is one of the very first things that the Insolvency Service do. So we do have some reservations with the fact that we're now moving away from a statutory form as such, because if someone makes themselves bankrupt, they will complete a statutory form and lodge it with the court and have it sworn before a solicitor. So this removes some of those elements. It removes the element of you won't have to have it sworn by a solicitor. And we can see from our engagement with the Insolvency Service that there are practical advantages in not having it as a statutory form, because this is the questionnaire is something that can be more flexible, can adapt to the time, so could adapt, for example, to bounce back loans and maybe include a question on that more readily, whereas if it was a statutory form it would be more cumbersome to include maybe more topical issues. So I can see both sides. I'm always a little bit reluctant to move from a statutory form, but the preliminary examination questionnaire as a document works extremely well. So I know that's a very long, convoluted answer.
No. So there's a balance, I suppose, is what you're.
Yes.
As you're saying, you're
Yeah.
just trying to sure we go. No, thank you. Just want to clarify that. So, thank you.
Gary?
Thanks, Chair, and thanks, folks, and thanks for your briefing as well. It was just I had a question around the digitisation, but you've answered that. The other thing I was just going to ask was your point 9 in your briefing paper. You talked about obviously strongly supporting practitioner education and support, obviously, and whatever changes are made. How do you see that? That's done through the Insolvency Service? Is that right? And in terms of that capacity, is that something? What else I suppose can be done in that respect?
Training generally originates from the regulating bodies of the insolvency practitioners or of the solicitors. So I would imagine this is an issue that the Law Society will focus in on CPD when there's been any changes. That CPD will take a variety of different formats. There'll be in-person events and then there'll be webinars which will provide just a general summary. This is a very niche area of law. So there's engagement within both the accountants profession, the solicitors profession, the actual licensed insolvency practitioners as well. And so it'll take a very formal context. Whether or not there needs to then be, there would be a whole suite of documents that are available to members of the public that may need to be adjusted on the Insolvency Service website. Okay. Some of the documentation is excellent. It's very user friendly. There's a guide to bankruptcy in particular, which I'm thinking of. There may need to be modest adjustments. This is generally a bill that is trying to bring us in line, so we're not necessarily innovating here. No. But there are some minor things that could trip people up if they're not aware of the change in legislation. So I think there'll be bulletins going out from the professional bodies, yes. But there may need to be public notice on the Insolvency Services website. But I think the CPD requirement, the Law Societies that's something that they excel in.
Absolutely.
Yeah.
No, thank you. No, thanks.
Insolvency Service have been really proactive, so we would be actively engaged with them to make training that is, I suppose, helpful from their perspective, but also relevant to our members.
Thank you. Thanks.
Is there anything else you want to put on the record now while you have the opportunity?
No. As I say, it wasn't really an objection that we had. Yeah. We just kind of, I suppose, it's the solicitor profession to nitpick.
No, 100%. Well, I appreciate your time. Thank you very much indeed for that.
Thank you.
Thank you. Thank you. Next witness is there.
It's in the way.
Or next witness.
Yeah, that's right.
Do you want to Maxie?
Okay, colleagues, we're going to see if William Gowdy from the Bar of Northern Ireland is available to join us now.
Just to broadcasting to bring him in. He's the sort of an electronic waiting room that he's in, so it'll just be on there. Here we go. Dear, he's not in the waiting room. So, members, while we try and locate, do you want to? What we might be better doing is going on to the statutory rules, if that's okay, at item 10 on the agenda.
We move to item 10 then, members, which starts at page 297. The Department intends to lay an SR entitled the Insolvency Practitioner Amendment and Transitional Provisions Regulations Northern Ireland. The rule is subject to negative resolution procedure. No date has been provided for when the rule will come into operation. Previous regulations set out the bond that insolvency practitioners are required to have. This appears to be a kind of insurance payment that insolvency practitioners would be required to make in the event of fraud or dishonesty on their part or the part of others with their convenience. The specific penalty sum provides separate cover for each of an insolvency practitioner's cases. The general penalty sum provides general cover for any cases where the SBS cover is insufficient. The proposed rule would increase the GPS from $250,000 to $750,000 and will provide for interest to be payable at a rate above the sterling overnight index average on claims under the SPS and GPS. The proposed rule will require the SPS provide cover for a minimum of 6 years and also provide for a minimum run-off period of 2 years following an insolvency practitioner's release or discharge, during which a claim may be made under the bond. The proposed rule will require the GPS to cover cases where there is no SPS and or when the SPS is insufficient to cover a claim. The proposed rule will require bond providers to provide specificity on what is covered and 60 days notice of when a bond is due to expire. The Department advises the proposed rule matches arrangements in England and Wales and is strongly welcomed by the insolvency bodies in Northern Ireland. Members have any questions on this? If not, are the members content that the Department make the proposed rule? Is that agreed? Yep. Agreed, thank you.
So on this one, the Department hasn't come back to me about whether executive rules defer.
Okay. Item 11 then, members, I had sought clarity on this because it says within the papers that this was required executive approval. Our request from the Department as to whether it has had executive approval to date has not been forthcoming. So my view is there's no point in the committee considering it until we have been informed whether or not it has executive. We haven't been told.
Okay.
So
it also doesn't come into effect until 17th of November, so we have time. So we do it next week.
I think it's important we get clarity. I would have obviously some concerns personally and sort of from a party perspective, but if we get that clarity first and then we come back to it.
Okay. Members, can we move to item 12 then?
Yep.
Okay, RHI Uplift Tariffs SL1, and I refer members to the cover note at page 344. The Department intends to lay a statutory rule entitled the Renewable Heat Incentive Scheme Amendment Regulations Northern Ireland 2025. The rule is subject to draft affirmative procedure and will therefore be debated in plenary. A copy of the draft regulations and explanatory memorandum can be found in the table of papers. The proposed rule will amend the Renewable Heat Incentive Scheme Regulation Northern Ireland 2012 to increase the tariff for support payments made under the non-domestic RHI scheme to accredited small and medium biomass installations. The increases are for heat generated from November 2025 and are expected to be based on meter readings recorded by Ofgem. The proposed rule will fix the tariffs for these installations for heat generated up to the end of March 2026. These uplift tariffs are the same as the closure payments that are currently out to consultation by the Department. The winter tariff uplifts will increase the costs of non-domestic RHI scheme by 10 million from the period November 25 to March 26. The Department appears to advise the Treasury had agreed to increase in costs for the non-domestic RHI scheme. The proposed regulations appear to have been designed following engagement with UFU, RANI and FSB Northern Ireland and align with the cost model devised by Professor David Rooney at Queen's University, Belfast. So I just wanted to try and seek clarity on this one as well to see if this has received executive approval. So we are unaware. So I think it would be useful before we make a decision on this to see if it has received executive approval at this stage, and if the Department can confirm that Treasury has also signed off on this, because if it's £10 million, we obviously there's a big financial burden, so we need to see clarity that they've done that.
This is what they talked about last week. This is the levels they talked about.
Yeah, so this is last week they obviously came in to brief on the closure tariff figures, which are the same as this, but this will only cover the period from November 2025 to March 2026. So this is similar to the winter uplift tariffs that were brought to the committee last year but were voted down by the Assembly, but the figures and levels of which are currently higher. So are members content that we seek clarity from the Department on two issues? One, that Treasury has given approval for this increase in the winter tariff, and two, that that's received executive approval?
Yep.
Yeah.
Item 13 then, members, is student fees. The Department has laid a statutory bill entitled SR 2025-164, the Student Fees Amounts Amendment Regulation Northern Ireland 2025. The rule is subject to negative resolution procedure in the Assembly. The rule will come into operation on the 1st of September 2026. The committee considered the related proposal on the 10th of September and was content for the Department to make the rule. The laid rule is understood not to deviate from the original proposals approved by the committee. An increase of 2.7% is to be applied to the basic and higher student tuition fee amounts for the academic year 26-27, which would see the maximum amount of tuition fee level increase from 4,855 in 25-26 to 4,985 in 26-27, which is an increase of £130. Members, any questions on this? If not, are members content that I put the following motion that the Committee for the Economy has considered the statutory rule SR 2025-164, the student fees amounts amendment regulation Northern Ireland 2025, and subject to the report of the ESR, has no objection to the rule. Members content?
Yep.
Okay.
Correspondence.
We'll do correspondence then, colleagues.
Yes. Finished by 10.
We have several briefings, we just have to find the witnesses.
Set us in traffic.
Okay, so these begin at page 401. Item 2, members. Members are asked to note a ministerial response in respect of the artificial intelligence and implications for the Northern Ireland economy. Members intend to note?
Yep.
Thank you. Item 3, members are asked to consider a departmental response in respect of support and innovation for science and artificial intelligence. The department's areas of research interest are linked to the priorities of good jobs, productivity, regional balance and net zero, which the members will be aware are the ministerial priorities. The department is undertaking a wider rollout of Catapult. 2 applications to the UK Government's AI Growth Zone programme are under consideration. Also included is the Matrix report on AI. Is the committee content to schedule an oral and written evidence session on the Matrix report of AI in Northern Ireland? Agreed. Item 4, members are asked to consider departmental response in respect of advanced manufacturing and innovation. The department indicates that AMAC continues to be underwritten by Queen's University and will fulfil many of the functions typically associated with a catapult. In respect to queries from the ADS group about outdated employment targets attracted to investment support, DFE appears to suggest that Invest in I employment figures may be varied across the contractual life of support to a company. Members content to forward the correspondence to ADS?
Yep.
Thank you. Item 5. Members are asked to consider a ministerial and CEO response in respect of an Invest NI board member resignation. Are the members content to note pending the forthcoming Invest NI briefing in December?
Yep.
Thank you. Item 6, members are asked to note a departmental response in respect of the establishments of the local economic partnerships, all of which are developing actions. Funding will be returned in October and the January monitoring round. Overall support will remain at £45 million, but this will be profiled over the remaining 2 years and not 3 years as originally set out. Members have any questions or concerns on this one? No. Okay. Are members content to note?
Yep.
Okay. Item 7 is to note a departmental response in respect of Northern Ireland Republic of Ireland student enrolments. The Minister met with their counterparts in the Republic of Ireland in June 2025. So, colleagues, I welcome the fact that the Minister is engaging with the counterparts in the Republic on this, but it doesn't actually set out in the response what the Minister is seeking to achieve with the engagement with the Republic. Is that she's seeking to have financial support from the Irish administration to fund the places that are currently being used within the Mass and Cap here in Northern Ireland. So I would be keen just to, first of all, welcome, the committee will welcome the engagement with the Minister in the Republic of Ireland, but I'm not quite sure what the engagement is intended to deliver. Members content that we seek clarity on what she's trying to
I raised this
Yep.
at British Irish Parliament just the other day with the Minister was there, the Irish
Okay.
Minister was there and was unaware of some of the issues I raised with triple the number coming, but we don't have it. We have a barrier south for our students and working. So there's a conversation definitely needs to be had there of how we allow the mobility and flexibility for all of our students. So
no, members content we seek that clarity.
Yep.
Okay, perfect. Item 8 then, members asked to note a departmental response in respect of Republic of Ireland students and the Mass and Cap. The department appears to advise that the increase in the number of student places here in Northern Ireland is matched by the increase in the Republic of Ireland students. So no additional places for students from here in Northern Ireland. Members content to note at this stage? Okay. Item 9, members are asked to note a departmental response advising of a post-skill send transformation bid. Members content to note?
Yep.
Thank you. Item 10, members are asked to note a departmental response welcoming the committee's endorsement of the LCM of the Sustainable Aviation Fuel Bill. Members content to note?
Yep.
Item 11 for noting is a ministerial correspondence providing notice of minor amendments to delegated legislation in Northern Ireland owing to a change in the name of the Scottish Qualification Board. Members content to note?
Yeah.
Thank you. Item 12. Members are asked to consider departmental correspondence in respect of the launch of the public consultation and proposed changes to certification of visitor and tourist accommodation in Northern Ireland. The changes cover quality standards, categorisation and alternative accommodation, visitors, registers and the display of charges. The consultation does not refer to Airbnbs. However, also and separately, the Department is to commission research on the relative impact of any of short-term let/tourist accommodation lets in Northern Ireland on the local housing market. Is the committee content to schedule a evidence session on this? Great.
Chair.
Yes, Sinead.
Chair. Sorry, no, I think, this is very interesting, and I think that we should seek a briefing and feedback on the consultation.
Agreed. Yeah, let's do that. Item 13 is for noting correspondence from the Minister for Education, acknowledging correspondence in respect of the initial teacher education bursary scheme. Members content to note.
Yep.
Thank you. Item 14 at page 595, members are asked to note correspondence from the Windsor Framework Democratic Scrutiny Committee. Members content to note. Yep. Item 15 for noting is correspondence from the Committee for Finance, providing a copy of the PFG budget alignment document provided by the Department of Finance. Members content to note.
Yep.
Thank you. Item 16, members are asked to consider a request from East Belfast Enterprise to meet with the chairperson to discuss concerns around the current Go Succeed programme and the new local growth fund. Members content that I do that.
Yes.
Thank you. Item 17, members are asked to consider an invitation from Caleb's Cause to members to attend an event on the 17th of November. Members content to respond individually to that.
Yep.
Thank you. Item 18, members are asked to consider correspondence from Act Now submitting its research report on Invest Northern Ireland F-35 and Israel public money for war crimes ? Is the committee content to note? Yep. Okay. Item 19, members are asked to consider further correspondence from a concerned individual. Are members content to note? Okay, thank you. We can then go back to item 7. Do we have our...
Well, we do not, but we do have Aidan from RHI, so we could go to item 8.
Yep.
And maybe if members are content, we might cut across Aidan if Mr. Gowdy appears, if that's okay.
Go on ahead, Ed. Whenever you're ready, Chief, no rush.
No problem. Good morning, Chair members. So here this morning to talk to you about the Insolvency bill paper that's in your packs. As members will be aware, the bill is both technically complex and lengthy, so I'll not go through the entirety of the bill nor its individual clauses. Members will also be aware that it is for the most part a parity bill in that its proposed changes seek to bring Northern Ireland insolvency law in line with changes to insolvency law in England and Wales, and sometimes, in some cases, Great Britain, that occurred between 2013 and 2015. There are two exceptions to this. The bill as introduced contains two provisions that are not found in Westminster enacted legislation. The first concerns the notification of the Enforcement of Judgments Office when a company is being voluntarily wound up, and the second concerns amendment to the Company Director's disqualification Northern Ireland Order 2022 as they apply to insolvent partnerships. The DFE previously explained to the committee in evidence that both of these proposed clauses seek to address gaps in the existing legislation. The department carried out a consultation on the bill's proposals in November 2024 that received just 4 responses. 3 of those responses were in favour of the bill. The 4th, from the Law Society Northern Ireland, expressed concerns about the proposed abolition of the requirement to issue a statement of affairs. They were concerned that the change would dilute the significance of that document. Subsequently, the Law Society further qualified its response, stating that its earlier comments did not indicate the bill's proposed changes were problematic. Given the limited response to the consultation, I went back to the United Kingdom parliamentary debates addressing comparable legislation there. This revealed that most of the proposed provisions were uncontroversial when introduced in Westminster. Some invoked debate. However, those provisions included new powers for liquidators to assign causes of action. Here there was some concern that the provisions could dilute ethics and professionalism in the insolvency sector. There was also debate about the removal to seek sanction, the need to seek sanction for liquidators and trustees to use certain powers. Here there was concern that the power could be used to appoint a bankrupt person to assist with certain tasks in the business. Debate was also around the abolition of requirements to hold a meeting in insolvency cases. Here there was concern that the minimum threshold for decision making was set too high. There was also debate about the removal of the need to prove small debts, particularly around the definition of what a small debt is. There was debate around the proposals that the official receiver becomes a trustee in the making of a bankruptcy, where there was concern that this could remove some responsibilities from the official receiver and some rights from creditors. And there was also debate on the protection of essential supply provisions, where businesses raised concern about the impact of equivalent provisions, and this led to safeguards being put in place through regulation. Ultimately, however, in each case, the proposals set out in the Northern Ireland Bill reflect the enacted position in Westminster. Moving on to the costs associated with the bill, the bill's explanatory and financial memorandum stated that the introduced bill would incur no financial cost to government. However, an earlier 2021 regulatory impact assessment by DFE found that the proposals could result in a familiarisation of costs to the official receiver to the amount of £5,133, and these costs would occur in year one only. Finally, the bill extensively relies on secondary legislation to implement the detail of the bill's underlying policy objectives. If the bill is enacted as introduced, it would empower the DFE and the Department of Justice to introduce rules and regulations in 96 areas. These would be subject to negative resolution procedure for the most part. The DFE maintains that this is normal practice when proposing and enacting regulatory insolvency procedural changes, because such rules are subject to scrutiny by the Insolvency Rules Committee. Many of the powers included in the bill affect the scope of existing powers. Others would provide new powers in new areas, including the abolition of meetings in company and individual insolvencies, the ability of creditors to opt out of receiving certain notifications, and the ability to amend the definition of a small debt. So thank you, Chair. That's all I wanted to cover, and I'm happy to take any questions.
Yeah, that's useful. Yeah, because there was very little reply to the consultation given the specificity of this. But we've had evidence before that your session, and then we'll have after. Is there anything that automatically flagged up to you that you believe the committee should be raising with the department in terms of concerns as to some of this legislation isn't a complete mirror copy of England and Wales?
Not particularly. There are some scrutiny points throughout the paper where there's small questions. Nothing jumped out, as I said. It mirrors Westminster. Those are either uncontroversial or they've carried over the final position there. That said, I'll caveat by saying I'm not a lawyer and also not an insolvency practitioner, so that's a lay person's look at it.
Anybody have any questions for Aidan on this? No. Perfect, sir. Thank you. Appreciate your time.
I think he's there. The committee consent to go to closed. We'll pardon?
Message to see if he's on.
We're still not there. So I think he's probably going to appear at 10:15.
Okay.
I think.
Are you content to move into closed session, members?
Yep.
Item 7, members, which is evidence from the Bar of Northern Ireland. The committee will now receive evidence from the Bar of Northern Ireland via Zoom in respect of the Insolvency Amendment Bill. I refer members to the Clerk's covering note at page 32, a written submission from the Bar of Northern Ireland at page 43, and I'm delighted to welcome William Gowdy, KC, Insolvency Practitioner at the Bar of Northern Ireland. William, thank you very much for joining committee today, and if we can hand over to you, if you just want to outline any concerns that you have in relation to the draft bill.
Good morning, Mr. Chairman. On a technical point, you referred to me as an insolvency practitioner. As you'll be aware, that has a specific meaning in the insolvency order. I am a lawyer practicing in insolvency, but I'm not an authorised appointment-taking insolvency practitioner.
My apologies, sir.
No. I just want to make sure the record is entirely clear and that no one is confused. Yes, the first point that I want to say in the context of the bill is that the bill is in the context of our insolvency law. The underlying purpose of our insolvency law is that of firstly, of providing rescue to people who find themselves in financial difficulties, finding them a way to be relieved of the oppressive burden of debt, and where they're in business, being able to start again. That's balanced by public interest considerations, where there has been misconduct on their part. The second purpose of our insolvency legislation is to ensure fair pro rata distribution among our creditors. So those are the high-level priorities that the Assembly, I would respectfully say, needs to bear in mind when it's considering this legislation. The second point is that in this area of legislation, policy has been for a generation that Northern Ireland should follow as closely as possible the position in England and Wales, and that the situation that we have here, where what is happening in Northern Ireland is lagging perhaps up to 12 years behind England and Wales, does not serve those purposes. Where we have the situation where Northern Ireland is using old rules and England and Wales has moved on, that does not serve either of those two purposes in general, in that it reduces the pool of those who are willing to take insolvency appointments in Northern Ireland, as the discrepancy grows on, and that has to be against the interests both of debtors and of creditors if there is less competition among practitioners to take appointments. The discrepancy also does, in the situation where one has insolvency practitioners based outside Northern Ireland taking appointments, does lead to the situation where there can be traps for the unwary, where there are perhaps old rules that are no longer serving the public interest that are still in place in Northern Ireland and are missed by insolvency practitioners, mainly practicing in England and Wales, and then there are technicalities. Those can lead to an insolvency process failing because of the technicality. A debtor, perhaps, who has invested in a rescue type process, such as an IVA, being told that has failed because their IP has missed that they need to file papers in court in Northern Ireland, to give an example, or in other situations where an IP misses a similar filing requirement or a requirement to hold an actual meeting, say, and as a result, that is then used as a technical argument to argue that a step in the process has become invalid, giving rise to cost, particularly legal cost, dealing with that issue rather than dealing with the substantive issues in the case, getting in and administering the assets. So my first key point is that there is clear public interest in catching up with the processes that have been in place in England and Wales now for some time, are bedded in there and are largely accepted by the insolvency community as working well. But that is in the context that we have to recognise that in a system of devolution, Northern Ireland is not England and Wales, and just because something is right in England and Wales does not necessarily mean that it'll be right in Northern Ireland. But that means that really we need to see where there are public interest issues in Northern Ireland where where public interest in Northern Ireland is different. And one issue where there is one issue that I would flag up here is the provision for the assignment of post-insolvency causes of action. That was certainly from the point of view of lawyers practicing in contentious insolvency situations, one of the perhaps more controversial provisions in the English legislation. If I roll back and say that it has always been accepted that an insolvency office holder, either in personal or in corporate insolvency, can sell the or assign the claims that the insolvent had before they entered into insolvency. So where there is an insolvent company that perhaps the reason for its insolvency is that a counterparty has breached a contract, that claim against the counterparty is clearly an asset that has always been capable of assignment. Up until the legislative changes in England and Wales, the claims that the company could not have brought itself, but that the insolvency office holder could bring, such as claims to set aside a payment made to one creditor at a time when there was not enough money to pay all creditors, or a claim to recover for the insolvent estate property that was given away for less than its market value. Those were not assets that could be sold by the insolvency office holder, but instead the insolvency office holder had to bring those in through the court process. In doing so, the insolvency office holder would be live to the fact that he or she acted as officer of the court and were acting not in their own interests, but in the interests of the creditors as a whole, and if there is a prospect of surplus, in the interest of the insolvent themselves. Obviously, if those causes of action are sold, there are no duties owed by the person to whom they are sold. And in the Bar Council's paper, reference was made to a case which is currently progressing through the court system, so I cannot say too much about the particulars of that case, but certainly there is an initial ruling from the Master which suggested that an assignment of this sort of claim raised concerns on from a judicial public policy point of view. Northern Ireland is a smaller jurisdiction than England and Wales. In England and Wales, there is an established market for the third-party acquisition of these sort of claims. There is not a market that I am aware of for those claims in Northern Ireland. So there is a real risk that this provision may, in the context of Northern Ireland, ultimately end up being a dead letter provision. The only context really in which one sees assignments being assignments of causes of action occurring in Northern Ireland is the context where, for example, there is an insolvent company that has a claim perhaps against its main lender or a business counterparty that the office holder is not sure about bringing, but the controllers of the company wish to bring, and that is then dealt with by the office holder, assigning it back to the controllers of the company so that they can continue to bring their claim. These sort of post-insolvency claims are not the sort of claims that the controllers of the company are going to want to bring back to assert. They are more likely to be the sort of claims that the controllers are going to want to get rid of. The English papers suggested that this might be something that would be of interest to creditors to bring. Again, I would say that in practice, I would imagine that would be overstated. Generally, creditors are reluctant to throw good money after bad in chasing after an insolvent company. There already is a situation where if an insolvency office holder does not have the fighting fund necessary to bring a contentious case, but there are creditors who are motivated to put something forward. The creditors can come to terms with the office holder so that the office holder case is funded, but the office holder brings the claim. So for those circumstances, I would say that even in England and Wales, the public policy for the assignment provision was more controversial. Those concerns, in my view, continue to apply here. They might even apply more strongly in this situation in Northern Ireland, where there is no established market for assignments of claims. So that is one concern. The other, the next issue that I want to move on to is the movement to a default of no meetings or other positions. That makes perfect sense. There is quite often these meetings are a rubber stamping type process and do not take place with everything being dealt with on proxies. However, the proposed legislation makes provision for a meeting to be called if requested by the creditors. I would suggest that there may be situations where an office holder considers that they would want to have the benefit of calling a meeting of creditors, and they would want to have provision to have a discretion to call a meeting. That office holders, as we know, are professional persons. They're regulated professionals. They're officers of the court. They are not going to do that unnecessarily, but I would respectfully suggest that we should not rule out the position that an office holder may wish to call a meeting of creditors rather than to write out and let creditors request a meeting. The other issue in that context is also then the move to a deemed consent situation. In other words, rather than require the office holders to come to have enough support from creditors to be able to say, well, we're going to do this unless you come back. What I would say is that generally where the office holder requires a positive decision of creditors, rather than having their discretionary powers to get on and administer the estate, it is something that is controversial. And the reason the office holder wants to go to creditors is that they are concerned that their discretion could be challenged. So from the point of view of both office holders and creditors, a deemed consent provision doesn't address that. In practice, I do not think there is significant disquiet with the approach of either asking creditors to support, or if the office holder is wanting to do something that they know may be controversial, but the creditors don't come back to invite the creditors' views, and then if there is nothing from the creditors to apply for the court to support that, that gives the office holder a security in those controversial cases that even a deemed consent won't do, because in those situations the office holders may be looking at a concern about a challenge from a former controller, from the bankrupt, or from someone who is perhaps not clearly a creditor. So my suggestion is that we should think clearly about whether there is a need for deemed consent rather than the qualified decision or the prescribed decision-making processes under the action. The other point is that when we come then to the question of the immediate appointment of the official receiver, that is a welcome proposal. It seems to have worked without issue in England and Wales. The one concern I would have about the legislation here is that it could be taken to suggest that the official receiver takes office unless either there has been an insolvency practitioner preparing a report under Article 248 or there is a failed IVA. And what I would say is that under the existing legislation, the court has, under its general power of administration and superintendence of insolvencies, appointed liquidators immediately in commercial litigation, in corporate insolvency cases, in circumstances where the petitioning creditor has been in discussion with the insolvency service. The insolvency service have not had the ability to act immediately, and the creditor has lined a insolvency practitioner up rather than have the steps of the official receiver take office and then very quickly the department make an appointment. There have been cases where the court has exceptionally appointed an insolvency practitioner to liquidate a company. Now, I appreciate that we are talking about bankruptcy. I cannot say that I have seen that in practice, but the same logic would apply, that maybe that consideration should be given to whether the legislation should not come close to ruling out the court's existing power in exceptional cases to appoint an outside IP immediately on the making of the order. So, in summary, those would be what I see as the key issues from the point of view of a barrister practicing in insolvency. Mr. Chairman, unless there's anything you would like me to address at this stage.
No, I think that's quite a useful overview. I just have one question from one colleague, Sinead McLaughlin, if that's okay, William.
Yes, certainly.
Thank you. Sinead?
Thank you. Thank you very much. I don't know if you can hear me.
Yeah, we can.
Thank you very much. That was very detailed. You mentioned, or you highlighted, that in England and Wales, any creditor can bring a petition under certain circumstances. What would be the practical implications of that difference between Northern Ireland and GB?
So in England and Wales, because Scotland's a very different personal insolvency, or it's a different in terms of its detailed insolvency system. In England and Wales, if you are a creditor with an undisputed debt, say you are a trade creditor of a sole trader and you have an unpaid account for materials, or you are the bank and there is an overdrawn current account and there is no way of paying that. In England and Wales, you can proceed immediately to present a statutory demand, which is a formal demand for payment, the implications of which are that if the debt is not paid in 21 days, you can then proceed to bankruptcy. And then at the expiry of the 21-day period, then the creditor can proceed to bankruptcy. Under the current practice in Northern Ireland, which was introduced as part of the response to the pandemic, a creditor other than the rating and taxing authorities cannot generally present a petition will not be entertained unless the creditor has first obtained a judgment. So you are incurring in Northern Ireland an additional layer of cost and delay. Now, one might say, well, look, that reduces the risk of people being put under the risk of insolvency when they're not really insolvent. That's one argument, but the contrary argument to that is that this delay means that where there is someone who is genuinely insolvent, but they have their head in the sand about it, that there is a delay and additional cost for the trading counterparty, who may themselves be a small business, in getting the situation moved on to the situation where perhaps they can make a claim on their credit insurance if they have that, or to get to the situation where funds are being divided equitably among all creditors, rather than the debtor paying who they can or paying no one and continuing to spend money without getting the help that they would get if they are in a formal insolvency situation. So that is what I would respectfully see as the current drawback from the existing between the current practice in Northern Ireland and the practice that formerly pertained for the emergency period in the pandemic, and the practice that is in England and Wales. Obviously, there are slight differences in the rules. The rules were wholeheartedly reviewed in England and Wales in 2016, and we have done some of that exercise here, but we haven't done entirely. But in the whole, that is the position. The position in England and Wales, you do not have that additional step of having to obtain a judgment from the High Court or the County Court first before proceeding to an insolvency remedy, even if you know that your as a creditor, your claim is entirely unopposed.
And so there's a delay factor then here?
Yes, delay and additional cost to the creditor.
Yeah. All right. Okay. That doesn't sound too practical. But then the other, you refer to the assessment of the rights to the family home for a non-bankrupt spouse. How do these differ between Northern Ireland and GB or England and Wales?
Well, this is probably something that would have been seen more historically before the legislation came into effect in 2009, providing that the trustee in bankruptcy had a period of 3 years to commence proceedings to realise the family home. The position in England and Wales was largely that no matter the delay, the trustee in bankruptcy's claims proceeded, while in Northern Ireland the court concluded that that in most of those cases the delay factor meant that the right of the non-bankrupt spouse and family to their family home overrode the creditor's interests. What it came down to was that in the context of Northern Ireland, the courts here weighed the factors that they needed to weigh under the Human Rights Act differently from those in England and Wales, and there were no cases that anyone felt were worth taking to the Supreme Court to come to a conclusion as to whether there is whether the courts were right to weigh those factors differently in the facts of those particular cases, or whether there should be the same approach taken in both jurisdictions. That issue is now almost entirely of historic relevance because of the 3-year rule.
Right. Okay, that's okay. That's fine for me. Thank you very much.
And then just finally, David.
Thank you. William, you said at the start about the devolved region and the sort of difference of the worry about translating something directly across. It's not always sort of equal in another part. So just to tease out a bit of that, you thought, the been able to lodge these in a county court in England and Wales and the High Court, where in Northern Ireland has to go through the High Court. So are you saying, and I've read this a couple of times and I'm just just to clarify this, but are you saying sort of that's the delay, the cost, the court time there, but is that something we should be looking to change for this, or are you happy enough with it the way it is presented?
So you're talking about the question about the practice guidance, saying that a creditor other than the taxing and rating authorities needs to have obtained a judgment before they proceed to bankruptcy proceedings.
Yeah.
So what I'm saying is that there is an additional delay factor in Northern Ireland, and an additional cost factor in required to obtain a judgment, which there was not under the 1989 legislation as enacted, and under the and is not the position in England and Wales. And from the point of view of, if the existing legislation is applied properly, my own view is that is a better position for creditors, and for genuine creditors, and so for people who are genuinely insolvent, than the situation where the creditor is required to incur additional cost and delay. The position would still remain that if the creditor has reason to believe that the debt is disputed on bona fide grounds, they should not be resorting immediately to insolvency processes, but will have to obtain a judgment from the county court or from the High Court first. The position is the point is that it's in the situation where there is no answer to the debt. It is a debt that is undoubtedly due but is not able to be paid, that it is contrary to the interests of the creditors as a whole, in my view, that creditors have to incur additional delay and cost before being able to access insolvency remedies.
Okay.
Yeah, that's good. Thank you.
Okay, William, thank you so much for taking the time to come to committee and providing that evidence. It's been very, very useful.
Thank you, Mr. Chairman, for accommodating me with the link.
Not at all, thank you.
Thank you.
So, Chair, is the committee content? I've already written to the department, just including the Bar of Northern Ireland submission, but I think there's a wee bit more detail there, and maybe just write to the department if you're content, and maybe ask them to perhaps come back with some explanation or assurances on the issues in question, if that's agreed, Chairperson.
Yeah. Members content? Okay. We'll then move to item number 15, forward work plan.
So, members, again, thanks for accommodating today. We're just very keen to get those witnesses in who are, as you appreciate, are expert. So next week, it's an even earlier start at 9:15 to get the Insolvency Practitioners Association. Also going to get the ESR in to talk about the very, very many statutory rules that are included in the bill, and then we'll have the department talking about the Apprenticeship Action Plan. After Halloween recess, then we hopefully will get R3, who are another insolvency practitioners group, in, and that's the day that we're going to hear from Lord Murphy on the Windsor Framework and the Road Haulage Association as well. So the plan, as I'd indicated before, is that on the 12th of November, we might do a wee closed session at the start, and members could then share where if they're feeling amendments coming on, where they might be. Then we'll go to open session, and then knife and fork our way through the 120 clauses and 4 schedules, where the chair will talk about what the bill does, the department will say what it thinks, and members can informally indicate where they are. And that should be that. In terms of other things that we'd had on the list, excuse me, AES Group, Kilrood, have indicated they regrettably can't come to give evidence to the committee because of ongoing legal proceedings, but have invited the committee at a subsequent point to come out and visit them and see all the various things that they are up to. I think earlier the committee did agree to take a briefing from Matrix on the AI report, which is in correspondence and is pretty good. So we'll try and work that in for the 19th of November if we possibly can. Could I also, if members are content with the forward work programme as is, or as amended?
Great.
And then, just under sort of an AOB thing, could I just ask the committee if it's content for me just to write to the department and seek sight of the RHI bill, Delegated Powers Memorandum, and the Keeling schedule as well, because it'll be helpful to the ESR if we get those quickly.
Yes. And the bill's up for second reading on Monday.
It is. I'm looking for other things, so the chair will make his contribution on behalf of the committee and also undoubtedly speak as his party spokesperson on these issues. Yeah, that will be second stage, and if it passes, then the committee stage will commence thereafter.
Chair.
Yeah.
I wonder, is it possible for you to share in advance the committee's remarks?
Of course.
Just a summary of them. Thanks.
Okay, I've never done that before, but
yeah, I'm very happy.
I think it's helpful because, you know, if you're speaking on behalf of the committee, just that we have clear sight of just exactly what has been said.
Yeah, I'm happy to send you a copy of my remarks, no problem, Sinead.
Copy that to members. Thanks, members.
And then you can send me a copy of yours.
No problem.
No kidding. No, listen, on this occasion, just given the sensitivity of the issue and the importance of it, I know that it's not normal convention, but I'm very happy to do that. Is that okay? Members, any other business you want to raise at this stage? Nope. If not, then the committee will adjourn and we'll be back at 9:15 tomorrow. Next Wednesday at 9:15. Thank you very much indeed.
Thanks, members. Thank you.